Judicial overreach. As President Trump pushes forward with his bold agenda, federal judges have repeatedly stepped in to block key policies, from funding freezes to limits on transgender procedures for minors. Now the Trump administration and its allies are firing back, with calls for judicial impeachment growing louder. Josh Hammer is the senior editor at large for Newsweek, and he joins us now. So, Josh, thanks for your time. Is there any legal basis right now for the opposition that Trump is facing in court?
Great to join you guys as always. So the short answer is no. The longer answer is that, you just call this judicial activism, judicial overreach here. I think that if anything, that's actually being charitable. The phrase that I like to use is judicial insurrection. The left has kind of normalized use of the term insurrection. We might as well just go a little fast and loose with that. Yeah, but it's worth thinking back to the first Trump administration. Donald Trump faced 64 so-called nationwide injunctions over the entire course of his first term. It's worth pointing out that was more than the first 44 presidents faced combined. There's a reason for that, by the way, which is that so-called nationwide injunctions were not a thing, so to speak, until the late 1960s, early 1970s, around the time of the Johnson administration, Nixon presidency. But conveniently, they really started picking up steam during, you guessed it, the Trump administration the first time there. But all of this entire notion that a random federal court judge in Hawaii or Seattle or here in South Florida or Maine or wherever has the ability to somehow bring the entire federal government to a halt. This is nothing less than juristocracy and judicial tyranny, the likes of which the founders would have been, frankly, just utterly, completely bamboozled and befuddled by. I mean, Thomas Jefferson writing in an 1804 letter to Abigail Adams, by the way, she's the wife of John Adams. John Adams and Thomas Jefferson, the viewers may recall here, didn't necessarily get along all too well. So this is not a particularly partisan issue back in the early days. Jefferson famously warned to Abigail Adams that if the judiciary were to decide issues not merely for the cases before them, but affecting the entirety of the federal government, that would make them nothing less than a despotic branch of government. Abraham Lincoln famously in his first inaugural address also said that the candid citizen must confess that when the Supreme Court decides policy issues not merely for Article 3, not merely for the judiciary, but tries to bind the other branches of government, the presidency, Article 2, and the Congress, Article 1, then that will make a situation where the people will have, quote, ceased to be their own rulers, is the language that Lincoln used there. So this debate goes back a very long time. But a so-called nationwide injunction is actually, frankly, technically speaking, an oxymoron, because the judicial power of which Article 3 speaks is simply the power to render a judgment as it pertains to the actual parties before a court there. So SCOTUS is going to have to hear a direct challenge to the constitutionality of so-called nationwide injunctions. Clarence Thomas actually presciently previewed this, as he so often does, back in his concurring opinion in the Trump versus Hawaii case, the so-called travel ban case back in 2018. Thomas's concurring opinion explained in very succinct, very straight to the point terms why so-called nationwide injunctions are unconstitutional. And he said that SCOTUS is going to have to step in if the courts continue to do this. Well, here we are 7 years later, and the courts are continuing to do it there. So I want to see SCOTUS once and for all rule that these things are totally unconstitutional and not part of the American way of life.
It would be about time if so, Josh. I mean, one thing that strikes me that's disgusting about all this is how all of it elevates the power of the bureaucracy and diminishes the power of the other three branches. And really what you have here is the judiciary being a tool of the administrative branch, the fourth branch of government, but also, I think also ruining their own power, because the more they issue these political statements, the more they make it more likely that Republicans say, to hell with agreeing with you about anything or listening to you. So on that note, you no doubt have seen that Elon Musk put out a poll after some chitter chatter, some talk with Mike Lee, Senator Mike Lee online. And this poll showed, of course, a biased audience, I suppose, but the poll showed a massive amount of agreement for impeachment. Now, could you walk us through what impeachment is in this, what would it mean in this case, and then give us your thoughts about that, about impeaching these district judges who issue these proclamations?
Sure. So I'll get to the impeachment question in just a second here, but Matt, just for a second, I want to focus on the first part of what you said there, because it's actually very important as well, which is that when judges overreach here, they only end up basically defeating themselves. That was my column this past Friday, is that this judicial resistance is ultimately going to end in humiliation for the judiciary, for Article 3, because they in fact are, as Hamilton famously said they are in Federalist 78, they actually are the least dangerous branch, because they have neither force nor will, but merely judgment. And as Hamilton said way back in 1788, 87 or so, they depend upon the efficacy of the executive branch, even for the enforcement of their own judgments. They literally do not have the ability even to carry out their own orders there. And it also kind of reminds me of Antonin Scalia's very powerful, stirring final paragraph of his dissent in the Obergefell case, the same-sex marriage case, where he famously said, paraphrasing here, the final line of his dissent was he basically said that with every decision that the courts make where it is clear, unambiguous overreach, we only come one step closer to being reminded of our own impotence. So that's actually a perfect segue to the judicial impeachment issue, right? Because Congress does have a lot of tools to rein in an out-of-control judiciary, including jurisdiction stripping or jurisdiction adding, actually, if you want to make their jobs even harder there, make them basically slaves to their desks 24/7. You know, as Sean Davis, co-founder of the Federalist, put it on X last week, Congress actually, frankly, has the ability to abolish lower courts wholesale if they want to. The Constitution only mandates that the United States Supreme Court exists, actually. Everything else is solely at Congress's discretion. Those courts only exist to make the Supreme Court's job easier, but if Congress wants to shake things up, they can there. Judicial impeachment is one of the most powerful tools that Congress has to rein in an out-of-control judiciary. So the actual language in Article 3 of the Constitution is it says that judges have life tenure, but they shall sit, quote, during good behavior. Well, we know from no shortage of constitutional scholarship on this issue, Matt, that during good behavior is basically synonymous with the high crimes and misdemeanor language that is used in Article 2 of the Constitution. They use different language. They basically meant the same thing. Well, what does high crimes and misdemeanor mean? Well, thankfully, we know that also thanks to Alexander Hamilton, who said in Federalist 65 that high crimes and misdemeanor amounts to a, quote, breach of the public trust. So that is the criterion that we're dealing with here. You want to tell me that, to take just one example here, Matt, that Judge McConnell up in Rhode Island, the guy who is threatening criminal contempt of the Trump administration if they don't submit all of their funding decisions through his puny little desk in Rhode Island there, you want to tell me that he is not breaching the public trust? The guy who Natalie Winters of War Room had a clip unearthed last week on social media that showed that Judge McConnell back in 2021 in the aftermath of the death of St. George Floyd, or a martyr, that showed Judge McConnell there talking about how he was a privileged white guy, but when it comes to rendering verdicts for LGBT or illegal aliens or black people, whatever, you have to make justice meet where they are. Paraphrasing, but that's basically what he said there. I'm sorry, but if you are an Article 3 judge who has sworn an oath to defend the Constitution, what that right there, what I just quoted, that is a breach of the public trust. These guys should be impeached.
Well, Josh, today we saw that Judge Tanya Chutkan, she's an Obama appointee who handled the Trump January 6th case. She went out and refused to block a Doge from accessing all the federal data, even though it was a Democrat-led push. So is the threat right now of even trying to impeach some of these liberal judges making them think twice before they're going to go overstepping all of their authority?
Well, I would like to see some actual articles of impeachment pass the House. So we haven't actually seen that yet, right? We have seen some congressmen say that they plan to file articles of impeachment there, and that's good. Those articles absolutely should be written. When it comes to someone like Tanya Chutkan, I do not think, frankly, that she is going to be dissuaded by virtually anything. I mean, we've all seen, the entire country has seen what she has done when it comes to the Donald Trump case there pertaining to January 6, 2021. So I don't think that she is a particularly good example here. Look, ultimately, these judges do have life tenure, and Congress, again, does have a lot of tools in their arsenal there, but those tools work within the context of life tenure there. So I don't think that she is a good candidate, to be honest with you, to actually be dissuaded from judicial impeachment. But surely for some of these other judges, when it comes to some of these younger Joe Biden nominees, perhaps there, maybe, just maybe, if Congress can actually get its act together and actually pass one of these articles of impeachment, then it's obviously an uphill climb in the Senate to actually get a conviction. But let's get this process started here. It can't end poorly. I mean, it can only possibly end in a good way there. So I say let's get this ball rolling.
That makes sense. I mean, Joe Biden put more judges right on the federal bench than any other recent president, I believe, and that's obviously part of the problem right now. Could you break that down for us when you look at the judiciary as a whole, the federal judges? What does that picture look like, and what besides impeachment should the administration and Congress be looking to do moving forward?
Well, Matt, as you know, the administration, I take the old school Lincoln view. I mean, Matt, you know, you and I are both alums of the Claremont Institute here. So to kind of go full Claremont Abraham Lincoln for a second here,
let's do it.
You know, Lincoln, I I mean, I mentioned his first inaugural address earlier here, but the stance that Lincoln took consistently starting in the aftermath of the Dred Scott case and the Lincoln-Douglas debates all the way through his presidency was he took the position clearly day in and day out that a federal court's proper jurisdiction, the actual meaning of the judicial power, is that it pertains to the parties in a case or controversy before that court. After that, the extent to which you want to extend the precedent to like-minded cases is essentially discretionary there, and it depends upon the persuasive authority of the judicial opinion. These opinions, after all, are literally called opinions. That's actually a point that I like to make time and time again. They're called opinions because they have to be persuasive in order for the executive branch to actually execute and extend the persuasive authority, similar to what Hamilton said in Federalist Number 78. So if I were a lawyer in the White House counsel's office, if I were advising President Trump, I would say that when it comes to these nationwide injunctions on any number of these issues here. So let's say birthright citizenship, right? That's a good example there. It's a very hot, high profile issue there. So, let's say hypothetically that a judge in Seattle or San Diego, whatever, rules where the plaintiff is the Honduran child of illegal aliens. I'm making a fact pattern here. Okay, we will respect this as it pertains to this individual. So the Marco Rubio-led State Department will therefore issue passport, social security number, but we're not going to extend that a millimeter further there. We're not going to do that at least unless and until the United States Supreme Court steps in. And then it's a more interesting question as to whether or not if the Supreme Court is correct there. But, we're not quite there yet. But really, before this starts to get truly out of hand here, Matt, I do think that the nationwide injunction issue has to be directly teed up for SCOTUS review. Mm-hmm. I hope that the acting Solicitor General of the United States is currently working on that cert petition. If she's not, then she probably should be, because this cannot go on much longer, or else this country risks unraveling into the very judicial despotism that Jefferson spoke of in that 1804 letter to Abigail Adams.
Yes, and I want to highlight this and just reiterate what you said, because it's so important. I mean, the principle is that the president can interpret the Constitution as well, and ought to, because he takes an oath to execute it. And, Trump has every right. In fact, it's his duty to interpret the Constitution and insofar as he has to defend and execute it. And therefore, he can regard the opinion of the court and take the opinion in that particular case and say, okay, you decided there. But insofar as the principles underlying, that's when something interesting happens when it comes to the separation of powers. And of course, I agree with you, because the only way to move forward is the left is going to be talking about the Constitution until the cows come home and be saying a lot of gibberish every time the administrative state or the fourth branch of government is touched. And Trump is going to have to stand strong and say no. And the same goes for the unconstitutional delegation of its powers of lawmaking, right? Congress, handing those over to the administrative state. I want to see a strong statement from the White House repeatedly that says, no, we're sorry, we don't think that this was constitutional. I guess what I'm curious about, though, I know you agree with me on these things, is don't you think that, what risks happening, a good risk, the good thing that might actually break out is a resuscitation of the separation of powers and maybe the resurrection of a kind of constitutional government that has some life in it again. And that's what's exciting me. It's like I'm trying to explain to people daily, even if the Dems actually decide to do more than just go to the courts, right? If you cut the courts off from them, what is that going to force them to do? They're going to have to pass a law, and then Congress will have to actually get into the lawmaking business again and dispute it. I don't want to be too white-pilled on this. My black-pilled heart is still slowly, uncaking and over time as the blood starts flowing in this new time. But do you think that that's possible? Do you see this maybe happening on the horizon?
Yeah, I think that Donald Trump is basically making departmentalism great again, Matt. So departmentalism is the idea that all three branches of the federal government, as you just said, have not just the right, but in fact the obligation to interpret and enforce the Constitution as it pertains to their own legitimate spheres of influence. This notion that just because a bare 5-4 majority of the Supreme Court says one thing, that 50, 60 years later, whatever, that future Congresses and presidents are bound by it. That's simply just not how it works. In fact, that all goes back to an erroneous decision in 1958, a somewhat obscure case called Cooper versus Aaron. It kind of unfolded in the broader context of the Brown versus Board desegregation fight, which is why no one likes to challenge it, because it gets into racial politics. But it actually has nothing to do with racial politics. It actually just has to do with the fact that the Supreme Court in that case, for the first time ever, said that we are binding on everyone because we are final. But definitionally, you are not necessarily final. I mean, the take care clause, for instance, of Article 2 of the Constitution says that the president shall take care that the laws be faithfully executed. Well, I'm sorry, but the law of the land, as defined by the Supremacy Clause of Article 6, does not include a bare 5-4 decision of the United States Supreme Court. That's not the law of the land. The law of the land is the Constitution, our treaties, our statutes there. So the president and the Congress absolutely have the ability and the obligation, the duty, to interpret and enforce their understanding of it within their sphere of influence here. So this judicial ruling from one of these judges, I literally can't keep track of them, also I forgot his name, but the judge who's telling Trump that he can't enforce his there are two genders, male and female policy, I mean, get out of here. I would just facially ignore that. I mean, you're going to tell me that you can't enforce your understanding of Genesis 127 biological dimorphism when it comes to your own Department of State, Department of Homeland Security websites? That is not a judicial order, okay? It might have the masking of a judicial order, but it is fundamentally, inherently illegitimate. And something like that, I think, frankly, should just be facially ignored. And on the contrary, not only would this not be a so-called constitutional crisis, to use the leftist media's favorite term of the day, this, to your point, Matt, would actually be a refreshing reminder. It would actually be a civics lesson, frankly. It would be a good opportunity to flex the sinews of Republican self-governance, I think.